This morning at 9:14 a.m. Eastern, a recording surfaced in federal court filings that fundamentally alters everything about this investigation. Before you dismiss this as another political story going nowhere, understand what we're actually dealing with. I'm not talking about speculation or anonymous sources. I'm talking about audio evidence, actual recordings, words spoken by identifiable voices, and a timeline so clear that prosecutors couldn't have scripted it better. After 3 decades building obstruction of justice cases, prosecuting organized crime and corrupt officials, I can tell you with absolute certainty, when you have someone on tape ordering the destruction of evidence after receiving a federal subpoena, that's not a gray area. That's a prosecutor's roadmap to conviction, the kind of evidence that makes defense attorneys start serious plea negotiations. I'm going to walk you through the actual recording, not what cable news says about it. I'm going to show you what was said, the documents that corroborate it, and the timeline of actions that followed within hours. Because what makes this recording different isn't just the content, it's the timing of when it was said, who it was said to, and the specific actions that followed. That combination transforms a private conversation into what the law calls consciousness of guilt. Let me walk you through exactly what's on this tape, word for word. The recording is dated June 27th. The location is Mar-a-Lago. The conversation involves the defendant and 2 IT staff members. The context is critical. This conversation takes place exactly 4 days after a federal grand jury subpoena was served demanding all classified documents be turned over to the National Archives. 4 days, not months or weeks. 4 days after federal investigators told him in writing to preserve everything. Here's the quote, the exact words captured. "I need you to make sure those files aren't accessible anymore. Can you handle that?" The IT director, confused, responds, "You mean delete them?" And here's the response prosecutors will play for a jury. "I need them gone today." The defense claims this was routine document management. But let me show you what the server logs reveal, because server logs don't lie. June 27th, conversation happens at 2:47 p.m. June 28th, at 6:23 a.m., barely 15 hours later, the IT director emails the systems administrator with subject line urgent deletion request. The email lists specific file locations that precisely match categories in the federal subpoena served 4 days earlier. June 28th, 11:15 a.m., the administrator confirms deletion of 472 files from those exact locations. June 29th, federal investigators arrive for a scheduled compliance check. They're told all responsive documents have been turned over. The server log showing these deletions is never mentioned. You might think people delete things all the time, that organizations routinely clean servers. Fair point. But let me show you why this is completely different. You've heard the term spoliation of evidence. In plain English, it means destroying evidence you know someone is looking for. But here's what makes it criminal obstruction. You have to know there's an official investigation, and you have to act with specific intent to impair it. The subpoena was served June 23rd, 4 days before this conversation. The defendant personally signed the receipt. When you delete files 4 days after a federal subpoena demanding those exact categories, that's not document management. That's consciousness of guilt. But this isn't the first time, and that's what makes the case devastating. In 30 years as a prosecutor, I've learned once is accident, twice is coincidence, 3 times is pattern. Patterns prove intent in court. March 15th, first incident. National Archives requests return of presidential records. 15 boxes eventually returned, but investigators later found significant gaps, missing categories, and testimony from staff saying they were told to remove certain items before sending boxes. May 3rd, second incident. Grand jury subpoenas surveillance footage from Mar-a-Lago showing who accessed storage areas. Footage provided, but metadata shows portions deleted the day before the subpoena was served. Defense claims technical malfunction. The IT vendor's technician testifies under oath that deletion was manual, not automatic, requiring administrator access. June 27th, third incident. The recording. Delete the files. Make them gone. Today, 3 times over 3 months, 3 different requests for evidence, 3 separate instances of deletion, concealment, or incomplete production. That's not bad luck. That's not organizational incompetence. That's a deliberate pattern specifically designed to obstruct a federal investigation. And here's what prosecutors will argue. The pattern shows intent beyond reasonable doubt. You might argue one deletion was accidental, but when it happens 3 times, each time immediately after investigators request specific materials, that proves you knew exactly what you were doing. So what does this evidence actually prove in a courtroom? Let me break down what obstruction of justice requires as a legal standard. To prove obstruction, prosecutors must establish 3 elements beyond reasonable doubt. Element 1. There was an official proceeding, that's the federal grand jury investigation. Grand jury subpoenas were issued under court authority. No dispute. Element 2. The defendant knew about that proceeding. He personally signed the subpoena receipt on June 23rd. His lawyers were in contact with the Justice Department. Multiple witnesses will testify he discussed the investigation. Knowledge is established. Element 3. The defendant took action with specific intent to obstruct that proceeding. This is where the recording becomes devastating. Delete the files, make them gone today. Spoken 4 days after receiving a subpoena demanding those exact files. The timing alone proves intent, but prosecutors have more. They have the pattern of 3 incidents. They have server logs proving deletions happened. They have emails showing the deletion was urgent and immediate. They have testimony from IT staff about what they were ordered to do. Some might ask, what if he didn't know deletion was wrong? What if lawyers told him he could manage documents? Here's why that doesn't work. First, subpoenas explicitly instruct preservation of all responsive materials. Standard language says, do not destroy, alter, or conceal any documents responsive to this request. Second, his lawyers sent a letter certifying full compliance with the subpoena after the deletions occurred. If lawyers didn't know about deletions, that's obstruction. If they did know, that's conspiracy. I've prosecuted similar cases. In 2018, a government contractor deleted emails after an inspector general subpoena. His defense, thought they were duplicates, was cleaning his server. The jury took 40 minutes to convict. Why timing proved intent, just like here. The legal standard is clear. Knowledge of proceeding, check. Action to impede proceeding, check. Intent demonstrated through timing and pattern, check. That's what the legal elements require, and the evidence satisfies everyone. Here's what happens next. Evidentiary hearing scheduled for February 18th. Judge will determine if this recording is admissible at trial. Defense will argue it's out of context. Prosecution will present complete timeline, server logs, emails, witness testimony corroborating every word. If the judge rules it admissible, that signals she believes evidence shows criminal intent. Trial starts March 4th. 12 jurors will decide if evidence proves obstruction beyond reasonable doubt. The evidence is in, and we're about to find out if the rules apply equally to everyone.